learned guests. Thank you for gracing us today with your presence as we going to tackle AI technology and the law. Thank you also to the organizers for this event who are organizing the IFLA Symposium on Artificial Intelligence, who have been greatly sharing with us the impact of AI and the legality of it and the ethical use of AI in the work that we do as librarians. My name is Ms. Sibongiseni Mkhwashu. I am currently based at the University of Forte as a senior librarian under Research Support Services. I have been given the honor today of being the program director to facilitate today's discussion on ethics in AI. I will shortly introduce Dr. Tsowole, who will be welcoming you today to the event. Dr. Tsowole is currently at the University of Lesotho, heading one of their technological services at the library. He will be doing our welcoming today. Dr. Tsowole, over to you. Thank you.
Thank you very much, Program Director. I hope I am audible enough for colleagues to hear me. By
Yes,
show
you
of
are
hands.
audible.
Okay.
Thank you.
Thank you very much, Program Director, and thank you to you, all colleagues. As the Program Director has said, I am Dr. Tsowole. I'm a senior librarian and currently the university librarian at the National University of Lesotho. On behalf of the IFLA AI Symposium Organizing Committee, I am delighted to welcome you to today's webinar on AI ethics in law. Colleagues, as artificial intelligence continues to transform legal practice, education, governance, and access to justice, it is becoming increasingly important to examine not only the capabilities of these AI-related technologies, but also the ethical responsibility that accompany their usage. So questions around fairness, transparency, accountability, privacy, bias, and human oversight are now at the forefront of legal and policy discussions the world over. So today we have the privilege of learning from two distinguished scholars from the University of Free State in South Africa. Our main presenter, Dr. Mati, who is a senior lecturer and vice dean for learning, teaching, innovation, and digitalization in the Faculty of Law at the University of Free State. His expertise and leadership in legal education, innovation, and digital transformation place him at the cutting edge of discussions on the role of these emerging AI-related technologies, especially in the context of a legal profession. Joining him is the co-presenter, Monique, who is a doctoral candidate and emerging candidate, also emerging scholar, also affiliated with the Faculty of Law at the University of Free State. Her research and academic contributions bring valuable insight into the evolving relationship between law, technology, as well as ethics. So we are honored to have both speakers with us today to guide us through this important topic and to share their perspective on the ethical challenges and opportunities that artificial intelligence technologies presents within the legal sphere. So thank you very much, colleagues, for joining us. We would like to encourage you to engage actively in discussions and make use of the question and answer session at the end of the presentations. Thank you very much, Program Director. Everyone is welcome.
Thank you so much, Doc, for welcoming us into this interesting session today. I must say that these are my keen interests. The collaboration of technology, law, and people. And our learned guests and presenters, they can share their presentations so long. Apelele, are you going to be presenting on your end, or will the colleagues present on their side?
They can present on their side. Thank you.
Okay, thank you. Dr. Jakas Meti and also Miss Monique Janssen, you can have the floor and present on your end. Are you willing on your side?
Good morning, colleagues. Yeah, just give me a moment.
No
It
worries, no
seems that
worries.
there's all kinds of permissions that have to be given first. So let's
Okay,
see if I can get that going.
thank you for that. As we're waiting for our guest to show up their presentation, something to think about. I want you at the end of the session to be able to answer the following question. Who is liable when AI is used? If it happens, for instance, let's say in your work that you do, you utilize AI, and for some unfortunate reason, it happens that the information is incorrect or it has been utilized in a manner where it violated intellectual property. Who will be liable in that case? I want you, as our presenters engage today, I want you to think about liability when it comes to the usage of AI in our everyday work, in the work that we do to empower our clients, researchers, and students as well. To think critically, who is liable? Yes, we can utilize AI and declare it, but who is liable if all things go wrong in using AI? Who becomes liable? At the end of the session, you're more than welcome to engage also on the chat on who is liable if all goes wrong and it happens that there might be some sanctions or some legality, who will be liable to take the blame when it comes to AI, as we're waiting for our um, our presenter of to showcase their presentation. Are you winning, Doc? Okay, it's coming
It
along.
seems
Thank you so much.
seems
We
like
can
it's
see it.
okay. Let me just see if I can at least get it full screen.
Okay, thank you so much.
Okay, so you'll just have to guide me if there's any questions.
We can see your hand now. We're not seeing your presentation.
Let me see. There we go. Can you see the
Yes, we can.
presentation now?
Yes, so we see it in presentation mode as well. Thank you
Okay,
kindly.
we
Over to
won.
you.
We got there.
Yes, thank you.
All
Over
right.
to you,
Good
Doc.
morning, everyone. Yes, good morning, and yeah, it's a pleasure to be part of this symposium, build up program. And I would really like to thank the organizers for the invitation. Now, my contribution this morning is going to focus on two things. Firstly, I just want to briefly situate the emergence of artificial intelligence within the legal profession. And then secondly, I want to ask, what does this actually mean for professional ethics? But rather than beginning with a definition of artificial intelligence, I think by now everybody's clear on what that is, what that means. I rather want to begin with a question. And the question is, if AI can do something, does that mean a lawyer should let it do it? Now, I think the answer is quite clearly no. And that distinction between what technology can do and what a professional should do is really at the heart of AI in ethics or AI ethics in legal practice. Now, firstly, if we have a look at how AI has filtered into the legal profession, so artificial intelligence itself is definitely not new. Um, it's only being put on the forefront now. It's only really emerged over the last couple of years that everybody's talking about it. But what has changed dramatically is the accessibility and the sophistication of contemporary AI systems, particularly generative AI. Now, AI is increasingly capable of searching and analyzing legal information, summarizing key judgments and legislation, reviewing large collections of documents. It can generate drafts and correspondence. I think all of us know that one quite well. I'm going to take a stab in the dark and say that everybody here uses it on a daily basis, especially when it comes to emails. But it can also identify patterns in large data sets, assist with litigation management, and of course, support client intake and what we call legal triage. So legal triage, just to get a quick sense of what a case is really about. I often tell my students that a part of our skill set as lawyers is really to listen and to dissect what a matter is really about. Because a client will come to you and they would start talking and they give you an entire story. And at the beginning of a consultation, you might think this client is coming to see you about a divorce matter. But by the end of the entire story, you realize, oh, this is actually about a delictual claim for defamation, something like that. But what we're also seeing now coming out is that AI can actually predict or assess the possible outcomes of a case. And this is actually linked to the fourth bullet from the bottom, where it identifies patterns in large data sets. So AI nowadays is capable of looking at previous court cases, judgments. Now, in law, we talk about the law of precedent, but what AI can do is to go through a bunch of court cases, judgments, and see what is the probability of a particular case going left or going right, if that makes sense to anybody. So what we're definitely seeing is AI is moving from a tool that lawyers use to a system that can actually influence professional judgment. And that really changes the ethical conversation. Now, AI capability does not necessarily equal professional competence. The fact that you can use AI does not mean that you are professionally competent. So AI can generate an answer, but at the end of the day, a lawyer must still exercise his judgment. Now, as I said, lawyers have always used technology. We've moved from physical law reports. I saw Hesma's name in the participant list now. Hesma will know about all of the court report, the law reports, the old stuffy books there in the library that nobody actually uses anymore. But that has all been moved and digitized to electronic databases. We've also moved from paper files to digital files, from manual searches to sophisticated legal research platforms. But what makes AI different in this context? Now, the important difference is that many of the traditional technologies retrieve, organize, and process the information. But generative AI can produce now something that looks remarkably like legal reasoning. So it can actually produce an answer that creates the impression that there was a panel of lawyers looking at a particular set of information and that came up with the answer. So it can not only generate an answer, it can formulate an argument for you, can summarize the case, it can even appear to reach a legal conclusion. But there's one important distinction. While it can generate the answer, it still cannot exercise that judgment that is needed as a lawyer. So the lawyer will always remain responsible for checking the accuracy of the work, protecting the client's confidential information, for acting in the best interest of the client, and for exercising that professional judgment over a particular case. Now, we have an act that governs the legal profession, and we also have a regulatory body, the Legal Practice Council. Now, between the Legal Practice Act and the Legal Practice Council's professional framework, it creates an important framework, that I can use that word, because technological mediation does not remove professional obligations. So between the Act and the Legal Practice Council, they also have a duty now to monitor lawyers' professional conduct in this new era of AI. So the fact that the lawyer used an AI system does not change the fact that the lawyer must remain professionally accountable for the work that is produced. So the basic principle here is technology can mediate legal work. It can make it easier. It can make it faster. In certain extent, it can make it better, but it cannot ultimately assume professional responsibility. Now, AI also amplifies existing ethical risks. And this brings us to the next point. So many of the ethical problems associated with AI are actually not completely new. It was just amplified now by the emergence of AI. So if we look at accuracy, for example, you have the professional obligation to be accurate in your work, but now you have to navigate the prevalence of hallucinations in generative AI work. Also, AI introduces new manifestations of these problems. If you look at confidentiality, you have always, as a lawyer, had to protect your client's confidential information, but AI now introduces new questions about where that information actually goes when you put it into the system. Who's the owner of that system? Who's the owner of the server where that information lies? How is it processed? Where is it retained? Who has access to it? If you look at independence, lawyers are expected to exercise independent professional judgment. But AI introduces now the possibility of automation bias, where we start to defer to the output of an automated system simply because it appears authoritative. And then there's, of course, discrimination. If historical inequalities or biases are reflected in the data that we use to train or operate an AI system, those patterns may potentially be reproduced or amplified. So we can think of the relationship like this. Accuracy can become a hallucination, confidentiality can become a data exposure, independence can become automation bias, and equality can, of course, become algorithmic bias. The accountability then can become the AI said so, but that Lance's answer is not action answering. Because professional responsibility does not appear simply because a technological system was involved. So my basic proposition is AI does not replace professional ethics, but it makes professional ethics more important. Now, there's 5 questions that every legal professional should ask, and we can summarize it by referring to it as the PDRJA test: purpose, data, reliability, judgment, and accountability. So first, if you look at purpose, what exactly am I asking AI to do? What am I using AI to do? There's a significant difference between asking an AI system to help me brainstorm ideas for a presentation and asking it to analyze a client's confidential litigation strategy. So we need to understand the purpose and the risk that is associated with that purpose. Data, I need to ask myself, what information am I giving the system? Reliability, can I actually trust the output? Judgment, what professional judgment must remain with me? And of course, the most important one, accountability. Can I explain, justify, or take responsibility for the result? So these 5 questions give us a very practical way of translating broad AI ethics principles into professional legal practice. And let's look at 3 of them in particular. If we look at data, legal professionals deal with an extraordinary amount of sensitive information. You are dealing with your client's identities, their personal information like ID numbers, addresses, salaries, those kinds of things, medical information, financial information, privileged communication, confidential evidence, especially when we get to litigation. So when we introduce AI into these workflows, we need to ask what happens to that information. And this is, of course, where legislation like POPIA becomes particularly relevant. So POPIA establishes the conditions for the lawful processing of personal information, including accountability, purpose, specification, processing limitation, openness, information quality, and security safeguards. But the practical question can be expressed much more simply. So when you're dealing with an AI tool, don't ask only, can I upload this, but may I upload this? So these are not the same question. A system may technically allow me to paste confidential information into it, but that does not necessarily mean that I am legally or ethically entitled to do so. And that distinction is going to become increasingly important as AI becomes embedded in our professional workflows. If you look at reliability, of course, you need to ask yourself, can I trust the output? And this is where AI hallucinations become particularly important. An AI system can produce a fictitious case. It can give an incorrect citation. It can invent a quotation. It can even state an incorrect legal proposition. Perhaps most concerningly, it can do all of this in extremely convincing language. So it can actually convince you that what it is saying is true, accurate, and of course, professional. So imagine that you can ask an AI system to identify authorities that support a particular legal proposition. It gives you 5 cases. The citations look correct. The summaries sound convincing. Your first professional responsibility is not to copy those cases into any court process that you are working with. Your first responsibility is to go and establish whether those cases actually exist. And you would often be shocked to see how many of them do not exist. Secondly, check whether the citations are correct. and whether those cases actually say what the AI claims to say. So you will often find that a citation is correct, but what AI says that case is about is nowhere close to what it was about. So the ethical danger is not simply AI error, it's unverified AI error. And this connects directly to another ethical risk, namely automation bias. When a technological system gives you an apparently authoritative answer, we become less inclined to question it. And that is particularly dangerous in law. Now, because AI is extremely fluent, that is where the danger lies. But fluency is not accuracy, and confidence is not reliability. So, one of the most important professional skills in an AI-enabled legal environment will be the ability to critically evaluate AI output rather than simply consume it. Fairness, transparency, and oversight. So, reliability is not the only ethical issue. There are three broad principles that we must highlight, and that's fairness, transparency, oversight. If we look at fairness, AI systems learn from data. Legal data sets are not necessarily neutral, so they may reflect historical inequalities, discriminatory practices, or unequal patterns of enforcement. But if those patterns are reproduced in an AI system, the technology may simply amplify rather than eliminate the existing problems. Transparency, if an AI system contributes to an important legal decision, the question is whether we can understand enough about its operation or output to evaluate it. In other words, can we challenge it? Can we explain the reasoning to a client? Can we justify the decision if it is later scrutinized? And third, oversight. The question is, who remains responsible? Now, there's a lot of sources that we can draw example and inspiration and recommendations from. For example, UNESCO's recommendation on the ethics of artificial intelligence places human rights and dignity at the center of AI governance, and it emphasizes principles including fairness, transparency, accountability, and human oversight. The OECD AI principles similarly emphasize human-centered values, transparency, explainability, robustness, security, and accountability. So these are international frameworks, yes, but they translate into very practical questions for legal professionals, namely, can the information be protected? Can the output be challenged? Can discriminatory effects be identified? Can the result be explained? And critically, is there meaningful human oversight? Because the underlying principle remains, AI can assist professional judgment, but it cannot replace professional responsibility. Now, ethical AI also requires governance. There's one final dimension that we must emphasize here. AI cannot be left entirely to the individual user. It is also an issue of organizational governance. So a law firm, a legal department, university court, any organization that adopts AI needs to think about things such as which AI tools are approved, what kinds of information may be entered into them, which tasks may be delegated to AI, what verification is required, what training do my staff need, who is responsible for monitoring the risks, and of course, what happens when something goes wrong. This is where frameworks such as King become relevant. Technology and information are not simply technical matters, they are governance matters. So responsible AI adoption requires more than telling lawyers, please use AI responsibly. It requires a framework that actually enables responsible use. So we therefore need to think about AI ethics at three levels: the individual professional, the organization, and the broader legal and regulatory environment. So, in summary, the principle to remember is, as I've mentioned at the beginning, use AI to augment professional judgment, not to automate professional responsibility. The technology is going to continue developing. The specific AI tools that we're discussing today may look very different in a few years, but the fundamental professional questions will remain. What is the purpose? What data am I using? Can I rely on the output? What judgment must remain? And who is ultimately accountable? The question is therefore no longer whether lawyers will use AI. They already are, and they will continue to do so. But will we use it responsibly? And that brings us very naturally to the practical side of today's discussion. If we accept that AI has to be used responsibly, what can these technology actually do for a legal profession? Now I'm going to hand over to Monique, and she's going to take us into that practical world by looking at AI in legal research and some of the emerging legal technologies that are changing legal practice. Thank you.
Good morning, everyone. I'm just going to share my slide with
Thank you, Monique. We can see your slides. Please just present them in presentation view. Thank you.
Okay. I'm going to, where is it now? Ooh. Okay. Can you all hear me and see the slides?
Yes, we can.
Yes, thank you.
Okay, perfect. Thank you so much. Good morning, everyone. Thank you, Dr. Mattia. That's really given us a really solid ethical foundation to build on. What I want to do in my presentation is take the same critical lens and apply it to something more practical. That being, of course, how AI is actually being used in legal research and where the cutting edge of legal technology sits right now. So, everything we've just heard about ethics isn't separate from what follows. It's the frame we should be holding onto throughout. So, welcome to the part dealing with AI and legal research and emerging legal tech innovations. Let's start with the bit that looks at legal research, automation benefits, limitations in this part, starting with the changing shape of legal research. So, a simple observation starts this part. We can see that legal research has always been labor intensive. Even with our digital databases, you're still formulating search terms, sifting through large result sets, and filtering for relevance. That takes time, no matter how good your research skills are. Knowing that as a doctoral candidate as well. So, what AI changes is the mechanism underneath that search. Automated pattern recognition and semantic search mean the system is looking for meaning, not just simply looking for keyword matches. But here's the more interesting shift. Clients are increasingly walking into consultations having already asked an AI tool about their problem. They arrive with a preformed view of their legal issue. That's reshaping client expectations, and quite frankly, it's also putting pressure on the traditional billable hour model. There's a real risk buried in this for the profession. If we don't adapt how junior lawyers are trained and used, the tasks that used to build their skills, something that's taught also in your introductory law modules, the manual billable groundwork are exactly what's being automated first. Looking at the benefits and limitations of AI for the legal profession through a general lens, we can see that the benefits, as Dr. Mattia also mentioned, it increases your efficiency, it saves costs, it makes it more accessible for clients, and provides you with data insights that assist with strategy in your management of your cases. But besides that, it also provides your firm with a cutting edge technology and provides appeal for you to draw savvy candidates who would like to either work with technology or already have skills that allow them to merge into your firm rather quickly. Limitations, however, also mentioned by Dr. Mattia to some extent, is the accuracy issues. Specifically, what I would like to focus on is the watered down summary. So, leaving out information, not honing your summaries as intensely as you would with your legal skills and knowledge. The unintended consequences of AI, and this is across the range from your employment law to your criminal law. Along with that, also in practice, is the bias, of course, the confidentiality and the fairness issues. Skills development also remains a big issue, particularly as you need the groundwork of acquiring research skills before moving on to using AI. Without the necessary knowledge and skills, the requirements will fall through the gaps as well. Then regulatory gaps mentioned in the Harvey LaRue article posted in, I think, 2025, indicated that our Department of Communications and Digital Technologies looked into regulating specifically how AI is being used through the legal profession lens. The Legal Practice Council, as mentioned as well, provided guidelines on AI in practice, how that will pan out, if there is any more amendments that will happen later on, remains to be seen. And then the Judge President's Forum also commented on the fact that AI is being used quite frequently, and it could lead to inaccuracy in your judgments being handed down. There's a case that I think dropped in the last week or two where a judge used AI and also hallucinations appeared in their judgment. Quite a big issue, as judges are expected to write their own judgments. So it's a very big limitation on the use for the legal profession in general. Let's move on to then the skills adjustment for legal professionals. So what does adapting actually look like? The resource material point to three things. First, entirely new hybrid roles are emerging, so people who combine legal expertise with real technical fluency. Second, even traditional legal roles now need a baseline of technological literacy. You cannot opt out of this anymore, so it can become exclusionary at some point. And then thirdly, and this is often underrated, the interdisciplinary and collaborative skills matter more than ever because these tools cut across traditional practice area boundaries. Moving on to how AI automates, starting with document review and case management. Let's get real concrete. Drawing on the OECD analysis of high volume administrative decision making, which applies well by analogy to legal case management. AI improves throughout and the throughput and consistency when you're handling large case loads, but, and this is the caveat that matters, output reliability depends entirely on data quality. Biased, incomplete, skewed, distorted data also distorts your results. So human oversight remains essential whenever outcomes affect legal rights, and transparency and auditability aren't nice to have. They are what sustains trust in these systems. So they become mandatory. The practical takeaway for a law firm is that AI can support your file management and discovery workflow, but it cannot replace real legal judgment or procedural fairness. So then how AI automates your workflow and algorithmic management, drawing on the ILO analysis this time. In practice, this shows up as an automated prioritization of document review, litigation analytic dashboards, and workflow optimization, and finally, automated time tracking and billing. Here's the risk that doesn't get talked about enough, though. Algorithmic management can obscure accountability and it can intensify staff monitoring. If you are a firm using these tools, that's a genuine confidentiality and workplace fairness issue, not just an efficiency question. Moving on to case prediction and predictive analytics. This is probably the most contested application. Predictive analytics uses historical case data to estimate the probability of outcomes, how long a case will run, and the likelihood of settlement. The benefits are obvious: early risk estimation, better budgeting, smarter settlement strategy, but the limitations are just as significant. Historical data can encode outdated jurisprudence. These models also cannot account for genuinely novel legal arguments. Correlation isn't causation, and opaque black box models reduce your ability to explain a recommendation in court or to a client. So the professional duty principle here is non-negotiable. Predictive output must stay advisory, but it cannot and never should be determinative. I've prepared an example for us to have a look at. I would just need the audience to please confirm for me if you can see the video once I started. Starting then with Lex Machina, which is the AI of LexisNexis. The judge's behavior looks at damages and timing analytics. It's a case prediction tool. This is a demo of sorts. Let's see if it plays. Let's just give it a moment. Apologies. Something is... If we have enough time at the end, maybe, if the video doesn't want to play, we can come back. Let me just see if we move on to... There we go.
Monique, were you able to
Yes.
share the sound of the video, or maybe is it not coming through?
Oh, apologies. I think it might be not coming through. Let me
Okay,
see if I can stop sharing it and share it maybe through my screen. Let's try again.
okay, thank you.
Thank you for informing me. That's quite awkward. Me sitting and listening to the video, it's not playing on your side.
Some of us were just focusing on the transcription of the video. So sometimes it happens with technology that it goes south, whereas you want to go north. No harm done. So just check if you are able to reshare it with us.
Okay.
If not, we'll have enough time to play it again right at the end. When you're sharing your screen with us, on the settings when you're sharing, you just need to ensure that you've enabled to share sound as well. Monique, audio phone.
Yes, you are audible. Monique, perhaps you should play the video at the end.
Yes, that also works as well. Oh,
That then. I'm going to share my slides with you once again as I did previously.
just note, Monique, when you are sharing, just ensure that you've enabled to share the sound as well, and then the
Will
sound will
do.
come through. Thank you.
Okay. So I'm selecting it, share, going back, and then from the current slide. Okay, so guys, if you can hear me, please just indicate, can you see the slides as well?
Yes, we can hear you and we can see the slides. Thank you.
Perfect. Okay, I'm gonna move on then to the next slide and come back to the videos. Can I come back to them later on so as to not waste any more time?
Yes, that is fine. Thank you very much.
Okay. Then we also have Westlaw Precision that looks at litigation analytics on judges, opposing counsel, damages. Another example is Docket Alarm. It's an analytics workbench motion success rates. It looks at pleading analytics. And then Blue Jay Legal, which looks at your machine learning based rulings prediction for tax and or employment law. The question, though, remains these tools, do they generally and genuinely improve access to justice as they are currently designed? We will come back to them for you to answer that question. Okay, then moving on to the benefits and limitations from different perspectives from a cross-disciplinary lens. This slide takes us to the next step. It's not about tools, it's about how AI is reshaping distinct areas of law, almost as a cross-disciplinary audit. Now, I'm not going to read through all of them. They are here for you to go through at a later stage. But what I want to emphasize here is that the pattern across all of them is the same. New technology doesn't just speed up all processes, It changes what the legal questions even are. Moving on then to the accountability perspective from an academic or regulatory lens. So Kwale and Odeku described this as an accountability gap. Responsibility gets diffused across designers, deployers, and users, and it becomes genuinely unclear who's answerable when something goes wrong. The principle I want you to leave with: when AI assists research or prediction, responsibility stays with the professional user, not the vendor. That means audit trails, explainability, and real governance structures aren't optional extras. Ready's 2022 work adds something important here too. Screening tools can unintentionally reproduce discriminatory outcomes, and in legal analytics specifically, that shows up as overweighing historically dominant case patterns or jurisdictions. From a judicial perspective, looking at South African case law regarding legal practices, how AI has been used, and how it's been found out, we can look at two cases that are worth knowing, starting with Parker versus Forsyth. It isn't an AI case, but it reinforces something foundational. Discretionary legal decisions require human reasoning and accountability. This means AI-supported prediction has to stay subordinate to that. My Wundler is the most well-known case and also a cautionary example. In this case, counsel relied on cited authorities without checking whether they actually existed. So AI hallucinations. Professor Michelle van Eck has provided us with 4 principles that I think are worth putting on the slide. AI has genuine uses but remains unreliable, firstly. Secondly, it creates efficiency but is not a shortcut around professional duties. Thirdly, output must always be checked and verified. And finally, it doesn't change the requirements of honesty and integrity. So again, a genuine question for the room. Should the technology be blamed here, or is this simply a professional conduct failure that happens to involve a new tool? Dr. Mattia referred to data protection earlier on in terms of the POPI Act. Now, Section 71 of the POPI Act restricts decisions with legal or substantial effect that are based solely, entirely, mainly on automated processing or filing, subject to certain exceptions and safeguards. Why does this matter for legal research specifically? Because research platforms process personal data embedded in pleadings, affidavits, and correspondence. If an AI tool is profiling or ranking or even predicting outcomes for identifiable people, the POPI Act safeguards and human review becomes mandatory, not optional. So the question then is, does Section 71 actually provide effective protection in practice? We can have a look at the section later on if we've got time as an exercise and get a few ideas from the audience. Let's look then at defensible AI research workflows. So pulling all of that together, what does a legally defensible AI research workflow actually require? 6 things. A clear definition of permitted use cases, confidentiality screening of inputs, citation verification protocols, bias monitoring, audit logs of prompts and outputs, and periodic reassessment of the tools themselves. That's a checklist that you can generally take back to your own workplace and practice. Let's move on to the second part then of this presentation, which focuses on emerging legal tech innovations. We're done with the research side now. Let's start by defining legal technology innovation. Now, this particular concept is not just about automation. It includes new architectures for delivering legal services, what's sometimes called platformization, computational reasoning tools, data-driven analytics, and programmable legal instruments like smart contracts. The evaluation criteria that matter for professionals aren't just efficiency and legality, There are ethical sustainability, cybersecurity, and professional accountability too. A case study on smart contracts by UN Citral. We can see from UN Citral, it provides guidance that confirms that automated contracting systems can validly form and perform contracts, provided the legal requirements of a valid contract are met. So in law terms, that includes consensus, legal capacity, legality, physical possibility, and then formalities. But for them to be met in terms of a smart contract, specifically, attention must be given to consent, attribution, and integrity. So, smart contracts encode contractual logic into self-executing software triggered by predefined conditions. Now, that sounds very elegant, but the legal implications are real. Interpretation challenges come about because code doesn't always capture legal nuance. Language is very important in law. Error propagation, where a bug causes unintended execution with unintended legal consequences following it. Difficulty reversing execution once it's happened, and cross-border enforceability complications. The conclusion I want you to take away is that smart contracts require hybrid legal technical governance, not simply blind automation. Moving on to the governance frameworks for emerging tech, we've got two frameworks worth knowing well. The first is then the NIST AI Risk Management Framework that treats risk management as continuous and iterative governance, measurement, and monitoring across the whole technology lifecycle. So from the start to the end, it frames technology risk explicitly as professional risk for law firms. The OECD's work on digital transformation and public trust makes a parallel point. Innovation has to strengthen transparency, accountability, and institutional trust, not erode it. Efficiency gains cannot just erode procedural fairness or explainability. Moving then to the case study on AI-driven litigation management platforms. An example of this would be Luminance AI, which was used or piloted by Weber Wenzel in South Africa. We can look at the videos once again later on once we've got a bit of time. So what we see is that these platforms integrate document analytics, timeline generation, predictive scheduling, and workflow automation. And the benefits are real: better organization, less administrative overhead. But the risks are real too, like vendor lock-in, moving on to cybersecurity exposure, opaque algorithms, and over-reliance on automated prioritization. Professional responsibility here means verification, contractual safeguards, and contingency planning. Let's start again. The next case study is that of your legal chatbots and conversational AI. Chatbots are used for automated client triage, mentioned by Dr. Mattia earlier on, information delivery and intake, and there's a genuine access to justice argument here, but the risks are real. Misinformation, unauthorized legal advice, data protection violations mentioned earlier on, section 19 and 71, and then consumer deception. So regulatory oversight and clear disclaimers are essential safeguards. They are not optional in any way or form. Then data protection and cybersecurity in emerging legal tech. I mentioned section 19 of POPIA earlier on. So this section requires reasonable technological and organizational security measures, such as identifying foreseeable risks, establishing safeguards, regularly verifying the use of AI and how it can materialize in your risks, and updating your use thereof against new threats. Innovative platforms aggregate sensitive data requiring, such as security safeguards, incident response planning, vendor risk management, whilst cyber incidents may trigger professional liability and regulatory sanctions. Let's move on then to the last bit of this presentation, which focuses on prompt engineering as a cross-cutting risk control skill. So we've looked at today the introduction as to AI in the legal practice, ethics, research, automation, and then now emerging tech. It all comes down to how AI is instructed and verified, which brings me to the next question. What is prompt engineering? It's seen as an iterative process of crafting, refining, and optimizing the input you've given a generative AI tool to guide it toward accurate, relevant output. 3 core techniques come to mind here. The zero shot, where you just ask directly, the few shot, where you give example pairs, and then the chain of thought, where you explicitly instruct step-by-step reasoning. Here's the framing I want you to hold on to. A prompt functions as a specification, what the AI may do, what it must not do, and how the output will be verified. In a professional setting, that makes it a genuine risk control skill, not just a productivity trick. So how do the LLMs produce outputs? We can see that an LLM predicts the next token repeatedly until it stops. That's fundamentally what's happening under the hood. It's a pattern completion system, extremely useful for drafting and summarizing, but it does not automatically verify truth or legal authority. A hallucination, as mentioned by Dr. Mattia as well, is a confident-looking output that's not supported by reality or your source material. The model fills the gap with what sounds plausible or what it thinks you might want to gather, even if it is a fake case name. And hallucinations get more likely exactly when your prompt is vague, when sources aren't available, or when specifics cannot be verified. So from a South African perspective, because we share a common law basis with quite a few other countries, sometimes what the LLMs do is they latch onto the terminology of another country, but it's something that you pick up quite frequently if you are well versed in South African legal terminology. To give you a practical example, if you are doing research on the law of delect and intellectual liability, we've got very specific labels, or is it labels? Can I say labels? Terminology, let's stick to that. When we're dealing with the elements of intellectual liability, whereas we would say, for instance, an act, wrongfulness, fault, or your causation, and then your damage, the LLM might change your terminology to look much more similar to that of the US, which is not comparable to our legal system, nor is the terminology comparable. If you're not well versed, you will not pick up on it, and it might sound plausible for you, and then if you use it, it can cause quite a bit of damage. So let's move on then to the 3 truth modes to teach the audience. Starting then with mode A, that summarizes text you've actually provided. It carries a low hallucination risk if you constrain it properly. Mode B synthesizes from known standards, guidelines, and carries a moderate risk and needs citations. Mode C claims specific legal authorities or facts, but it carries a high risk and the tool needs to refuse it if it isn't sure. Why would you ask, does this matter so much in a legal and maybe an HR context specifically? The reason being because accuracy and traceability matter more than fluency. A model can be persuasive while being completely wrong. So what does the anatomy of a professional prompt look like? And on the slide, you will find there's a 6-component template. And it's important to understand that a professional prompt functions like a mini contract. So these 6 components start with role, which assigns a role matching the task to reduce creative drift. Jurisdiction and scope, stated explicitly and exclude what is out of scope. So let's say foreign law, international law, your specific jurisdiction. Source constraints, specify what's permitted and require the AI to flag when it cannot access something so it does not simply hallucinate. Task definition, be precise about what you want produced. And then output format, where you should specify the structure, word limit, tone, and audience. And then finally, verification and uncertainty rules, where you require citations, flag uncertainty, and explicitly prohibit fabrication. This is an example of a reusable prompt template stating exactly what we just spoke about. So what I want you to take away from this slide is that the role, jurisdiction, scope, sources, task, format, verification is the default structure that can be used anytime when you are using AI for professional work. So in the brackets is where then you would be including what is necessary for your search. Let's move on to then what is a bad prompt versus a good prompt in a legal research context. So asking a question such as, for a bad prompt, what does the law say about using AI for hiring? As you can see, it's not saying anything about jurisdiction, no authority constraints, which means it invites a generic answer with a real risk of fabricated citations. Now, here's the same request properly structured. Walk through the good prompt in this then order, which is role, scope, sources, task, format, and verification. Now, in walking through your prompt, you would then be including with each one of these parts the role, the South African Legal Research Assistant. You are performing that role as the scope. AI in recruitment and employee screening. So either from a labor perspective or from an HR perspective. Your sources being POPIA and then the Employment Equity Act, which applies only, the relevance of that being that POPIA looks at personal information and your information that's being used as a candidate, whilst the Employment Equity Act protects you against unfair discrimination, even if you are an applicant. So if a section number cannot be cited, say the section is not verified, or this is the section, the content, you need to verify the content. As for the task, a compliance checklist must be generated for AI using AI screening tools. The format then looks at the risk issue, practical control, the legal policy anchor, and the evidence to keep, whilst verification. Do not invent cases or section numbers and flag uncertainty. Now, from a labor perspective, this already is quite risky, as there are cases, or there have been cases, specifically from, I think it's Amazon in the US, where they have used AI in recruitment and employee screening, and it's actually shown that it is biased against certain vulnerable persons, which includes then women, people of a certain age, and then of a certain race, because of historical data, and then the way in which it filters through the CVs and the responses, which can, of course, then cause or lead to unfair discrimination. Again, if we look at a case prediction example, the bad prompt will be who will win this labor dispute, give a probability, very open-ended. Whilst the better, non-predictive, professionally safe prompt would be identify legal issues and plausible arguments for both sides based on these facts. Do not predict outcomes, provide a what to verify next list along with the missing facts and then missing documents. So I've got a live experiment method here for us, which is a workshop activity. Just want to check our time. We still have, I think, more or less half an hour left. If you guys can just confirm for me, that would be great.
Yes, Monique, you may proceed. We do have enough time.
Okay.
Thank you.
So let's quickly do then the live experiment method. Let's run the bad prompt, save the output, and then continue through with this. I'm going to give you guys a moment to quickly look at the prompt here. Let's use this bad prompt. What does the law say about using AI for hiring? Are you able to copy and paste it, or would you like me to copy and paste it for you into the chat box?
Yes, please. You may copy and paste it for us in the chat. Thank you.
Okay. Here we go. Going to go back to my slides and share it with you in a moment. Can you see anything on your side yet? Okay, let's
Not
go
yet.
back from the current slide.
Your slides are currently not showing.
Oh, okay. Technology. Let me try again.
Thank you. Yes, we can see them now. Thank you.
Perfect. Okay, so if you guys want to, you can, on your side, run the bad prompt and then save the output. Now, in that prompt, then we can highlight the vague sections, the unsupported claims, invented citations, and the wrong jurisdiction. So don't try and change anything to it. Just put it into chat or wherever you want to go and run it quickly. I'll give you a minute to do so. I'm going to go back quickly just to show anyone who's maybe confused as to what the prompt should be. It should be the what does the law say about using AI for hiring? Okay, so what have you guys seen on your side? I've put mine through chat. And on my side, it says it depends heavily on where the employer and applicant are located. So it's picking up on the South African perspective. And it says that there is currently not a standalone South African law that comprehensively regulates AI recruitment. In this case, it's very true because we do not yet. In fact, Cabinet withdrew the draft national AI policy in 2026, again, also because of hallucinations. And then it goes on to looking at the Employment Equity Act, at POPIA, labor law, and then constitutional equality rights. Now, for someone who is not legally well versed or trained, this might look like, yes, this is a very good answer because it gives me an overview of the legislation and it tells me what is relevant. But can you guys see in this particular response or what we've received from chat, it doesn't say anything about the particular sections. It doesn't give you context as to that. So
Sorry,
in the
Monique.
employment, yes.
We can only see your live experiment slide. Were you meaning to share the result with us? The chat
I can
result?
I can do that for you. Sorry, I didn't want to move it so as to avoid movement too much, but let me do this on my side so I can show you and run you through
Thank you.
that. typing in all caps. Okay. Going to share my screen with you now. Can you see my response?
Yes, we can. Thank you.
Okay, in my previous response that I had on another device, it showed the South African part, but I'm going to pull it up now. This one shows there is currently no single South African AI hiring law, and then it jumps directly to what that means for an employer. Do you see there is no jurisdiction included here outside from a mention of South Africa? Also, no sections entirely, it just mentions discrimination, it mentions candidate data, so POPIA comes into play. It also mentions that don't assume the AI made the decision, removes your responsibility. It doesn't say anything about the King Code mentioned by Dr. Mattia. We're moving from the fourth King Code to the fifth King Code, which places an obligation for your executive to also know how the AI functions. So that's also not included here. It's quite outdated, even though it mentions 2026, April 2026. It goes into AI generated assessments that need particular caution. And then it jumps to the European Union. Now, from a legal perspective, I'm able to more or less put together, because this is within my research field, that it's alluding to, the Employment Equity Act, the POPI Act. It's not mentioning the Constitution here, which is actually quite sad, because, the Constitution is the roadmap to our legal system. So Dr. Mattia mentioned earlier on fundamental human rights and values, which includes then your right to dignity, equality, to privacy, and all of that then filters down to the legislation I mentioned earlier on, employment legislation, such as the Employment Equity Act. So if you are reading this, you will think this is a very good answer, but legally speaking, there are quite a few gaps.
Are you still
here.
with us?
Are you still with us? Yes, I'm still with you. Can you hear me?
You are currently not audible.
We can hear you.
I'm
Yeah, we
able to
can
hear
hear
you.
It might be a network issue.
Can hear her.
Okay, so Dr. Mattia, can I continue? Can you hear me?
Yes, we can definitely hear you. I'm just gonna see if I can put in the chat that we can hear you. I think it might be on that colleague side. We can hear me.
Okay. Thank you. Chat really isn't giving you much. Now, I mentioned earlier on the European Union. From a legal perspective, for me, the European Union is not a regional body that we look at generally because we are bound in some way. It's not even on our continent. We rather look at the African Union. But the European Union is at this moment a trendsetter at the forefront of regulating AI. So it pulls into your response, and there is relevance in terms of learning lessons or drawing lessons, legally speaking, but it is not binding authority. So in a legal practice, if this is drawn as an answer and it's used as is, it will not be sufficient, and there might be real gaps in what you provide as a legal professional. Okay, so the next bit of the presentation is supposed to, and please tell me if you can see my slides now. Can you see my slides?
Yes, we can.
Perfect. So the next bit then asks you to save the output. We're not going to do that as to save time. We've already highlighted vague sections Unsupported claims, there are very little, but we can see that it doesn't latch onto newer changes. There's not enough time to look for invented citations, but the wrong jurisdiction was also included in terms of only the European Union. The International Labour Organization should have been mentioned here, or at least the United Nations to some extent. If we run the good prompt, though, we will see that there's an entirely different answer being given that's a lot more precise, specific, with the correct jurisdiction, and there might still be some unsupported claims or information that you should be checking. But again, that is why the guideline is to ensure that you verify whatever is given to you by AI if you are using it in a professional capacity. So prompt patterns for legal professional practice. What we can see here is the grounded summarization pattern, where it says that you should be only summarizing the content provided, no added flag missing information as it's not stated. The citation enforced research pattern that provides legal principles only when authoritative source link can accompany each. The two-layer pattern, which is both operational and legal. We've got the first layer where there's a practical control workflow, as we've discussed earlier on, and then layer 2, where there's a legal ethical principle justifying the control. And finally, the defensible memo pattern, which is for AI-assisted workflows, where the goal, scope, data set description, quality measures, human oversight, and audit trail is involved. So moving on then to mapping your verification guardrails, which includes then your NIST AI risk management framework I mentioned earlier on, onto prompt controls. This refers to govern your policies on AI use and approved tools, map understanding context, stakeholders, and rights impact, measure evaluating accuracy and hallucination rates, and manage, which is the mitigating through human review or escalation. If we translate the OECD's principles into prompt rules, transparency means requiring the tool to show its assumptions. The robustness means treating output as a draft until verified, and accountability means the human stays responsible with review steps built in or embedded in. Which leads me then, we're almost done, to the professional responsibility using AI. There are 3 pillars: competence and supervision. You need to understand that the tool's limitations and actively supervise its output. Confidentiality discerns prompting alone cannot fix this. You need approved tools and real policy on what staff may and may not enter into an AI used in the legal practice. Communication and reliance risk. The frame outputs as draft material until verified and require the tool to flag uncertainty. And we can look at the South African Legal Practice Council's guidelines on this specifically. Finally, we look at the prompt laboratory with mandatory rules. There are 4 rules before we continue that you need to consider, which is never include confidential client data into a public AI tool. Save your output, mark what was verified, and treat AI as a drafting assistant, not as an authority. And the document that you use with the prompts included, that is your audit trail. With the quality checklist for AI outputs. Now, there are 10 items scored 0, 1, or 2, along with your jurisdiction, your sources, your verified citations, your scope, uncertainty, flagged, confidentiality, bias consideration, human review format, and audit trail. Anything under 14 or scored under 14 out of 20 needs revision before you can rely on whatever was generated for you in a professional capacity. If we pull everything that we've discussed together today in this workshop, from the emergence of AI and law, through to the ethics, through the research automation, to legal tech, one principle keeps recurring. efficiency gains are only defensible when they are paired with verification, human oversight, very important, and this is across the board for any use of AI, and then accountability. And this is where the Legal Practice Council comes into play as well, in an overarching sense. So that concludes my part of the presentation. What I would like to do, if we've got a bit of time left, is go back to the videos that I wanted to share of the AI being used in practice. Can I get confirmation on that, please?
Yes, Monique, you may proceed. We do have enough time. You can play the videos.
Perfect. I'm so excited to share these with you and show them to you, but it seems like technology is not with me today.
It happens to the best of us. Apologies. Why don't you play it via YouTube? Are you able to do that? Maybe
I
it
am able. I
might.
think very good idea. Can you hear any music when it starts playing, or does it still not play?
No, there's no sound. There's no music.
Okay, then I'm going to go to YouTube instead. Okay, can you see the YouTube video?
It's coming along. There's no sound. Monique, if the issue still persists, you're more than welcome
It's going
to
to
just
start
drop
now.
the links. Okay.
Simply going through. Okay, I think that is much better. Okay, here we go. Give you guys time to look at these then.
Thank you.
There's the very video.
Thank you, Monique, for sharing the links, and they are accessible. And
It's my pleasure. I think that concludes then my part of the presentation. If you guys want to go and have a look at this later on, thank you so much for the opportunity, and Dr. Mattia as well.
Thank you so much, Monique. From my own opinion, if I was the one who was going to be awarding the PhD to you, you would have it by the end of this session. What a well thought out presentation, very detailed, and it made us think quite critically as well. That and also to see a practical example also in another field. We are information specialists, so we always assume or we might think that the issues that we are facing, they're not being faced by the other professions that exist. That was quite a mouthful, but quite informative as well. We've picked up a thing or two from yourself and also Dr. Matthew as well. I'm gonna, before I ask any questions on my side, I'm gonna open up the floor to the participants and the colleagues that are in attendance. Are there any questions? You are welcome to type it in the chat, or you can unmute yourself and ask the question. Okay, as we're still waiting for the questions, thank you so much once again, Monique, for the presentation. I must say, law is a little love of mine as well, and technology as mentioned at the beginning of this session. I wanted to ask, when it comes to the research that you are doing, when it comes to the prompt engineering and AI, LLMs as well, generative AI is also evolving. Does the science of prompting change over time? This is based on when first the AI started out, it could do basic, simple tasks. And as it evolves and learns, and there are new aspects into the LLMs, does the science of prompt engineering also evolve? And how would you advise we keep up with that one? Thank you.
Dr. Mattia, would you like to answer this, or would you like me to continue?
Yeah, no, you can come in, but from my side, I can say I think the science of prompt engineering is changing continuously because these systems are continuously being fed new information. They are continuously learning, and the more information we give them, the more changes and adaptations they are making. So the prompts that we're using today will definitely not be the same that we're going to be using within a year's time. Monique, I don't know if you have the same view.
Dr. Mattia, I agree 100% with you. I think if we take the fact that, a few years ago, we didn't even know about generative AI and how to use it. It wasn't accessible for us at all. Never mind prompt engineering. It's something that is continuously changing. The way we understand it is fundamentally changing AI in itself. We attended a conference last year in Stellenbosch, and I think what was quite interesting for me was that I was in a room with the most well-read the giants in labor law specifically, and they said, we are using AI, we are referring to it, but we don't fundamentally understand from a technology perspective what AI is. And that includes the prompts. So I think in this instance, it continuously changes. We need to stay up to date with it, and we might need to start building into our prompts lines that say something along the lines of, let's say, please ensure that the information is updated, because the LLMs also are only updated on an annual or how can I put it, in a biannual basis. So some of the information might already be outdated, as I mentioned earlier on, with the fast-pacing changes that we see with the guidelines and with the legislation and with papers being published. So the information definitely is outdated, and that should be something that's noted in your prompts, specifically in the context of the legal practice as cases, legislation, all of that drop consistently.
Thank you so much for that. There's a question on the chat from Esther Kruger. I would like to know what are the presenters' views on AI marking students' assignments? What is the privacy issue, if any, around these? Thank you, colleagues. Any one of you can take the question.
Interesting question, because I know there's divergent views on this.
Mm.
So maybe I can answer it in this. So first of all, I actually use AI in marking my students' assignments. But of course, I use it in different ways. So just to give an example, for my research report students, what I do there is I read their work, and then I make like high-level notes on the feedback that I want to give students. Because over the years, I've employed different methods of research feedback, from audio notes that I made to students which they ignore, to track changes and comments in the document which they ignore, to consultations which they ignore, to color coding which they ignore. So I've resorted now to making very high-level comments, and then I will ask AI to convert my notes into a logical format and into a report, and also highlight the what do I want to say, things that work and things that can be improved. But that said, I don't see necessarily a problem with using AI to mark students' assignments. I've seen from my own experience in using it that especially if you use it as a sounding board, as a to bounce ideas off of, it really helps, and it also cuts down in terms of the time it takes to mark some of the work. Of course, that will mean that there has to be disclosure that this was used in the marking process, and you have to limit what you give it to mark. Now, when it comes to things like a master's and a doctorate, I would be more wary of doing that. And of course, you must be mindful of the fact that where does that data go? Where does it lie? Who's going to use it after that? Is that going to result in a similarity, the document being flagged for high similarity? Now, in all of this, these exercises, I will call them, that I've done, I've never included students' details, student numbers, student names, any of that. I think that's still a no-go area. I think that should still be left confidential. But yeah, I think as long as there's open transparency, and of course, it also depends on which tool you use. Now, I know Blackboard had most a built-in AI system that we could use for that purpose. I'm not sure about the new platform. I must be honest, I'm off the top of my head, I can't know. I kind of can't remember now. But if it has a platform, I think we should explore using it to help mark the students' work.
Thank
Monique,
you.
I don't know if you.
Can I chime
Yes.
in here? I've got a
Yes.
perspective on this, and I'm also going to do a bit of marketing here, so please forgive me for that. So at the start of this year, Dr. Mattia, and on behalf of the law faculty, is actually the program director of short learning programs that I was privileged enough to form part of and to lecture in, and it focuses on AI in educational policy. To answer your question, Estia, the privacy issue, are you referring to only the information that's being uploaded, or are you asking on an institutional level?
Thanks, Monique. Yeah, I made a comment now to Jock that I specifically wondered about student names and student numbers. And he answered,
Okay.
because our policy says, that you cannot rely on AI marking alone. Of course, there needs to be human input as well. But yeah, I wondered, about the students' details. I mean, I agree with Jock that regarding research, maybe new research results and so on. Of course, you can't share that. But I know, I'm a librarian, but I know more and more of our lecturers are using AI tools to help them mark.
Mm. Mm. Okay, so the reason why I'm asking, and I'm happy that you clarified as well, is because in that short learning program, we looked specifically at institutional governance. And one of the biggest issues in nationally and also internationally is that quite a lot of institutions don't have policies, AI policies per se, but they do have guidelines, and guidelines are not necessarily binding. So it's like fumbling about in the dark a bit, trying to discern what is allowed, what is not allowed. And of course, later on, the regulatory issue of, accountability or liability, who will be held responsible should the information be shared in a way that is unlawful, that contravenes the Poppy Act. There's a specific case, I think, in Germany of a professor that also used a personal subscription of either Chat or Claude. I cannot remember quite well. But in doing so, he uploaded research. It's either dissertations or thesis, and he used it to actually assist with the grading. But somewhere along the lines, the LLM was updated and the settings changed, specifically settings relating to privacy and the way in which the information is stored. Now, that is a very big institutional regulatory risk that you run, because again, it's an employee that's using resources that's not approved by an institution that might not necessarily have a policy on AI use. So, from a student perspective, I think that's something that should be making you very uncomfortable with your personal information and how that's being stored, how it's being used, and how it's being kept. So, moving forward, we should probably start looking at policies, not only guidelines. If I remember well, it's only Northwest University that currently has an AI policy. You can come in and correct me, anyone who has knowledge on this. So I think it's something we need to keep in mind. And also, Prof. Mike Perkins recently posted something about using AI to actually mark student assessments. And he said, you sit and you draft this complete comment. You put it into AI, or the lectures that you give the feedback to as an examiner, and it dilutes whatever feedback you've given it. It slims it down and you lose the essence thereof. So not entirely relevant to privacy, but definitely something to consider. That's my
Thanks,
Thank you,
Monique.
Monique.
Thanks for that.
Thank you so much. Before I ask Hlongwana to just unmute themselves, Prosper has a comment saying ISO and IEC have produced the ISO 42001 and other standards on artificial intelligence, and then these might assist and help in using AI. Thank you so much for that, Prosper. Hlongwana, you can unmute yourself and ask your question. Thank you.
Okay, thank you. Thank you so much, colleagues. Am I audible?
Yes, you are. You may proceed.
All right, thank you. The session is very informative, and I, for one, really enjoy attending such sessions on AI, because AI is evolving and one needs to keep themselves abreast with the latest trend and so on. My worry is really on the fact that, is AI really the innovation that we need, or it's just a technological hype? Because earlier on, Monique mentioned that she had attended a conference, and it was mentioned that we all talk about AI, but we don't fully understand what it is. And I see this as more of a technological hype, which brings me to my question. So, do you think maybe um, because AI is talked about, it's the most talked about trend currently, it's the technological overhype. Do you think maybe the institutions adopting AI faster, then they can develop like proper governance framework is the problem? And if so, what can we do to sort of like strike a balance between adopting AI and actually having proper governance in place, or is this balance ever realistic? Would we ever get to a point where, you know, there's a balance between the adoption and the governance? Because it was mentioned also earlier on that it's mostly guidelines that other institutions have. And I know with the IIE, if I'm not mistaken, there is a guideline on the ethical usage of AI. But like in a more realistic and broad spectrum, like when we talk about the governance frameworks, how do we strike the balance? Because we can see that AI is evolving and we are all talking about AI and we are all shifting more towards using AI, and especially in the higher education industry. But now, how do we strike the balance of having proper governance frameworks in place? Is it something that might be realistic in future? Thank you so much.
Thank you for that. Over to you, colleagues, Monique and Dr. Matthew.
So I can give you my very short and frank answer to this, and I say yes. I think we are going to reach a tipping point where everybody has now become accustomed to AI. We have all the governance processes and policies and everything in place, and we're going to that's going to be the way forward. It's like with any new technology that comes out. I mean, when computers first started entering the arena, everybody freaked out until they became accustomed to it. There was regulations about using that. The same goes for email, and there's a lot of these things if you go back in history. So. You know, no, not to be flippant about it, but I've at one point also said that kind of feels like AI is now the new COVID. We were hit with this a sudden, unexpected thing, and now we have to adapt to it very quickly. But once the dust has settled, we will settle into a rhythm and move on. Point is just, I don't think it's going to go away. It's here. And remember, AI is not new. It's been there for very many years. It's just suddenly it's out there. It's on the forefront, and it's being thrust into everybody's lives. And we mustn't forget, it's also because there are these companies like Deep AI and all of that are making money out of this. But yeah, my short answer is there is going to reach a point where the dust is going to settle. We're going to have our governance policies and all of that in place. Everybody has gotten over the fearful monster that is AI and settled in, and it's going to become the norm. Does that mean AI is going to replace our thinking, what we do? No, I don't ever see a situation where it's going to replace anything, but augment. And that's also how I approach it, is I approach it as a tool to augment what it is that I am doing, but never replace. I hope that answers your question.
I've got Dr. Mattia, if I can chime in for a moment.
Yes.
I read an article in preparation for this that indicated specifically within the legal profession that 78% of firms in South Africa will be training their staff for the usage of AI. So I don't think in our legal capacity necessarily or our legal profession it's going to disappear at all. As in the presentation, you know, it's simply a situation of skills that will continue to change. So in law, we see drafting as very important. That's going to be augmented by AI. It's already being augmented, but other skills become so much more important. And we see this from a labor perspective as well. Soft skills, communication, collaboration, cultural literacy being one of the ones that are very important. And from that, we can see it simply changing the way in which we work, but it's not going to replace, as Dr. Matthias said, you know, your employees in general or your workers. What I want to mention, though, from a regulatory perspective, currently we don't have an AI policy nationally, you know, that functions over all of the sectors and work, inclusive of higher education and the legal profession. But that's not a situation that's unique to South Africa, because the technology, as Dr. Matthias said, even though it's not new, you know, we can trace it back to the 1950s. For the last 70 years, it's been a field of study, an academic field. But we can only see real changes coming about when the fourth industrial revolution hit. And I mean, we are currently on our way to the fifth industrial revolution, where these skills are becoming more important, not necessarily only the technology. But internationally, everyone is racing to regulate AI, which is why it's so important to look at the European Union, what they are doing, the United Nations. In your different contexts, there will be international law to draw from, regional law to draw from, that's relevant to South Africa. And as soon as we've got our own AI policy, I think things might start taking shape then, specifically in the context of the higher education sector, as asked about. Now, from there on, I had something to mention as well, which I think I've forgotten now, so I'm going to just stop there whilst I am ahead. But I hope
Maybe
that answers
Monique,
your question. Yes, Doc.
maybe while you're trying to gather that thought, so what I want to add to something you said now is, I think that's very important. And in my current position as vice dean, that's also my approach to this now is, we are going to send graduates into a world of work where this technology is being used. Whether we agree with it or not, whether we like it or not, it's there, it's going to be used. So we should rather shift the focus towards preparing our students to be able to use it, to have that skill, because that is henceforth, it's going to become a factor that either increases or decreases somebody's employability. Now, and again, there's views on AI and all of that, but one cannot overlook the benefits of something like this, especially in our field. Court cases take a long time to go through the process, but the use of AI can shorten some of those processes considerably. I mean, when we talk about preparing for a trial, documents, processing documents, reading through documents, to gather it, or looking at the evidence, all of that, that takes a considerable amount of time. And AI is proving to cut all of that down tremendously. And also, it not only cuts time, but it cuts costs. And that is, of course, a big plus in our field, because it will help to enhance what is the drive for social justice and access to justice and all those kinds of things. So there is, of course, a lot of disadvantages, a lot of drawbacks, a lot of things bad about AI, but we shouldn't undervalue the benefits that we can have here as well. But yeah, I just wanted to make that point. And oh yeah, that is why it's also so crucial for the university to get these guidelines in place as quickly as possible, to get the governance in as possible, so that we can start to focus more on training or teaching our students and our staff how to use this properly, responsibly, and to augment what it is that we're doing instead of replacing it. Thanks.
Thank you so much, Dr. Matthew. Just one final question on my side. Excuse me, because these LLMs and most of these AIs, they are not originating from South Africa. I wanted to find out how would you advise we safeguard from bias, and also how do we flag the bias when it comes to the AI use, pertaining particularly to unfair discrimination and political agendas, if there are any that are existing at that time, and also addressing human rights issues. How would you advise us as professionals we flag the AI? Because primarily in the library and information science space, when we are being taught and told about the AIs, we are told that they are operating, some of them specialized one, in closed loops, that they are only feeding into, or they are only learning on a closed loop system, learning from particular and specific information. But then we assume that there might be no bias there off, and also everything will be good and sound, above board, if you might. Just that part before we close today's session. How would you how can we safeguard from bias when we're utilizing the AI professionally and also when we're assisting our clients? Thank you.
So what I can say on that point, because yeah, that is still a difficult one to tackle. So a couple of things. So I would say it will obviously depend on the tool that you use. I mean, your mainstream AI platforms, you know, your ChatGPT, Claude, all of those things, of course, they are not based in even the African continent. They are not from an African perspective. So my first advice would be any outputs that it gives, of course, you have to verify, but more specifically, the sources. Ask for the sources and check the sources that they use. If they're not typically African or South African sources, then I would be very wary to trust what is in there. Now, of course, if you're a subject specialist or if you know your field, you will also immediately pick up if information is not accurate. But then I also want to add, there's really a proliferation of these AI platforms, and some of them now originating from South Africa, from Africa. I mean, there's a couple of them that I know of that that were built from a South African perspective and an African perspective, and that also include other sources or jurisdictions in Africa. So there, you would be more inclined to trust that those do not have bias. So it depends on the source code they use, the information that they rely on to give you that output. Now, how you will know as the user what that information is, I don't think you will necessarily be able unless you ask or you have access to that. But yeah, Monique, I don't know if you can add anything else to that.
Dr. Mattia, I think you've mentioned the majority of what I wanted to mention in terms of the new startups or innovations locally. But I think in future, what might become more important is to also have your interdisciplinary teams involved so that you have those checks and balances of people with subject-specific knowledge, reading through, checking, verifying, and of course, outside of the knowledge itself, but picking up on where there might be a possible bias because of skewed data or data that perpetuates historical inaccuracies. So important, you will need to have human verification, checking the data, checking the outputs, and making sure that the final end product, if I can put it like that, is not discriminatory towards anyone based upon any of the grounds that we discussed earlier on, whether it's race, gender, anything that can possibly perpetuate what happened previously or a new form of discrimination. So I think the interdisciplinary and collaborative way forward would be best. And then, of course, drawing from knowledge base that is South African and African, so that specifically, it serves the community at large here.
Thank you so much, colleagues, for the engagement. We are now coming to the close of today's session. I cannot thank you enough for the engagement and also for the questions that allow us to think critically about the usage of AI in our profession as we perform our tasks. But before we close, at the beginning of the session, I asked a question about liability on if all goes wrong, who will be liable? If you utilize AI and perhaps it may have given you bias or misinformation, and you utilize that information, who will be liable? And I'm sure that you have noticed that that question was answered by both the presenters, respectively, and in depth, that professionalism does not evaporate at the sight of AI. One needs to use it ethically and human oversight, professional judgment, and to act legally as well, and for the benefit of our clients and also the institutions that we serve. With that said, I'm going to hand over to Ms. Nambita Mangola, who is currently the Assistant Director at the Library and Information Services at the University of Free State, to give us the vote of thanks. Over to you, Ms. Mangola.
Thank you, Program Director. I'm audible.
Yes,
Hello.
we can hear you. Thank you.
Thank you so much. Let me take this opportunity. Oh, sorry. Good day, colleagues and distinguished guests. Sorry for being rude. Some of you were not here when I was earlier on the platform. I would like to take this opportunity and thank you, Dr. Mati and Monique, for a very informative and eye-opener session. This session that you delivered us, it's not just a normal session, it also proved to us that it's not only LIS sector that is battling with the AI. It cuts across all professions. With those words, thank you very much for the informative session. And the discussion was not only showing us the importance of information literacy, however, AI literacy, copyright, intellectual property, privacy, data protection, and on top of that, it also prevails the importance of research integrity and the responsible of information use. Thank you very much for that. To our attendees, thank you very much for keeping up with us and listening to our presenters and being interactive with us to show that you really indeed this information that we are given, you indulge with it as they are presenting. Thank you very much for your attendees. If I don't thank my organizers, I will be failing them. Thank you very much for organizing this informative session that created not only engagement, however, it broadens our professional development and the knowledge that you are sharing with us. Thank you, our program director, for steering the ship. I don't have words, but thank you very much. I would like to also take this opportunity to remind you once more, September is around the corner. We all know September in South Africa, it's all about heritage. Therefore, I'm challenging you to think and guess the next session that I will have, but I'm already given you a hint. See you on the 17th of September. We're going to have another session that we are building towards our AI Symposium that we're going to have in Ponteval in November. I'm hoping that you're going to see Dr. Miti again, depending on our negotiations. You know, all the speakers that I'm bringing here, I always negotiate if they are coming back, depending on the love that you are showing to them, that you still need them, you still need to engage with you. Dr. Mati, thank you very much. Keep an eye on my email for further discussion that I will be carrying on behalf of the committee to have a call back for November event. Thank you very much. In those words, this should be adjourned. I bounce out. Have a lovely day and marvelous weekend ahead. Thank you very much.
Thank you. Thank